two main elements in the state of Florida. As I stated in the first question, they, from a legal standpoint, one is procedural in nature, and the other is more substantive in nature. And what does that mean? Well, the first criteria that has to be met is that the side that's arguing that it's unconscionable had to have either very limited or no options to negotiate the contract. So basically, it's called an adhesion contract. And what that means is that from a practical standpoint, it's take it or leave it. So I had mentioned on one of the other questions that you have a scenario where you have these blank forms that will be sent out, and the party will say, sign this form, and you say, well, no, I need to amend form number 4. No, you either sign this contract in full without any amendments, without any addendums, or you don't get it at all. And so the person signs it. So that's the first criteria, and they consider that to be procedural in nature. The substantive one is that you have to be able to show, if you're arguing that the contract is unconscionable, that the contract is so one-sided from a perspective of what kind of benefits and what kind of obligations the party that's arguing that it's unconscionable has. So anytime you have a contract, you have certain entitlements in that contract that you'll get, and then certain obligations, the things you have to give. And if the giving is so much on one side and the entitlements are so little, then that may in fact meet that second criteria. Having said that, if you have a scenario where there's been what's called in law an arm's length transaction, in other words, both sides had the ability to think about it, both sides had the ability to do due diligence, and one side just signed a bad contract, that's not enough to make it unconscionable. You have to have it where there are very limited options, and you have to have it where one party gets so much versus the other party and has to do so little versus the other party. One of the other things that's kind of interesting when you talk about the criteria or the elements that you have to prove an unconscionable contract is that courts have, they require that both of those elements be met, but they don't have to be met in equal amounts. So it doesn't have to be, well, 50% of it is that we didn't have the option to do any negotiations, and the other 50% is the fact that it's a very, very one-sided in so far as entitlements and obligations. You could have something where the entitlements and obligations really is kind of the minimal part about the contract, but basically it was a take it or leave it. And so that may be deemed to be unconscionable. But those are the two elements that you need to prove in the state of Florida.